I humbly submit my opinion and speculation that a Fifth Avenue law firm wants to take a profitable and wealthy client's money. That's what I think is happening here. And if I was involved in the case, I would be crying ethics and possibly submitting some kind of Rule 11 sanctions motion. This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. This is going to be, I'm going to do this one a little bit differently than we usually do these. I'm going to power through two documents, Gigi Hadid's memorandum of law in support of her motion to dismiss. What are we dismissing? The exclusively lawsuit, where we'll get into the exact facts of it, but it's essentially that a paparazzi took a picture of Gigi Hadid. She's a model. This happens. And then he published the photo. He has a license. He's the copyright owner, and he can license it as he sees fit. And then she posted it on her Instagram without a license or without permission. And so now she's being sued for the copyright violation. Defendant, Jelena Nora Gigi Hadid, by her attorneys, respectfully submits this memorandum in support of her motion to dismiss the complaint. Ms. Hadid is a famous American supermodel. It is an unfortunate reality of Ms. Hadid's day-to-day life that paparazzi make a living by exploiting her image and selling it for profit. This lawsuit takes that practice to a new level. The complaint seeks substantial monetary damages from Ms. Hadid based on allegations that she found a copy of a photograph of herself online and reposted it to her personal Instagram account, where it remained for a matter of days. The plaintiff in this case, exclusively, we're going to call them exclusive, did not take the photograph at issue and identifies no harm it suffered on account of the allegedly infringing conduct. Exclusive nonetheless brings claims against Ms. Hadid for direct and contributory copyright infringement. Its complaint is fatally flawed in multiple respects. Exclusive does not allege that a valid copyright has been registered for the photograph, nor does it allege the requisite written assignment or licensing agreement that expressly gives Exclusive the right to bring the accrued claims of the unidentified photographer, and the complaint establishes that Ms. Hadid's reposting of the photograph was fair use and consistent with an implied license. So I'm going to be focusing on that last part, that they're saying that Ms. Hadid's reposting of the photograph was fair use and consistent with an implied license. Let's see if that's true or not. We're going to read through her motion in support, or memorandum in support, and then theirs in opposition. In light of these fundamental defects, this lawsuit appears to be nothing more than an effort to extract money from Ms. Hadid, presumably based on a calculation that even on a meritless case like this one, the anticipated cost of litigation would cause Ms. Hadid to pay out a modest settlement. This sort of misuse of the Copyright Act should not be countenanced. For the reasons set forth below, the complaint should be dismissed. Okay, so they're now saying this is misuse of copyright to sue her for posting another copyright owner's photograph on her Instagram. Being followed and photographed is not an uncommon experience for 24-year-old Ms. Hadid, and in that respect, October 11th, 2018 was a day no different than most. As Ms. Hadid exited a nondescript building in New York City, she encountered a photographer waiting for her outside. Although these encounters are often disruptive or even unsettling, in this particular instance, Ms. Hadid decided to indulge the photographer. She stopped and posed for the camera, and in that moment, the photographer snapped a photograph. I don't have permission to republish the photograph, and I don't really care to, so you can go find it on your own. Sorry. The next day, Ms. Hadid allegedly found a copy of the resulting photograph published online and reposted a cropped version of it to her personal Instagram page. The cropped version allegedly remained on her Instagram page for a matter of days. Months later, Exclusive filed this suit. All of the complaint offers about Exclusive is that it is a domestic business corporation that operates out of Queens, and it claims to be the owner or exclusive licensee of the photograph, and that the unidentified photographer took of Ms. Hadid last year. Exclusive makes no allegations about how it came to have any rights in the photographs. Okay, well, that will be part of a copyright claim, is that they will have to prove ownership. Right here, we're on notice pleading, where they have to put you on notice that they have one. You can go search, I guess, yourself in either now or through discovery to get copies of ownership documents, but they would have to be presented by the time the thing went to a bench trial or jury trial. Although Exclusive alleges that the photograph is the subject of a valid and complete application, Exclusive's name appears nowhere in the copyright registration page attached to the complaint. Exclusive makes no allegation that the copyright in the photograph has actually been registered. This is a valid argument. If there's no valid copyright registration, then this complaint cannot be brought. So that's a perfectly valid argument. Based on Ms. Hadid's reposting of her own image on her Instagram page, Exclusive brings the claims for direct and contributory copyright infringement. It does not allege any damages actually suffered as a result of the alleged infringement, and nor does it have to. When you register a copyright, you do not have to provide proof of damage. You have to provide proof of registered copyright, and then the strict liability of copyright statutory damages kicks in. And then the judge gets to decide on a scale of $750 to $150,000 what is the appropriate number. In its prayer for relief, it says the maximum possible statutory damage penalty is 150 damages. 150 damages. Each damage is worth 1,000. Exclusive seeks the maximum possible statutory damages permitted for willful copyright infringement. That is $150,000 per infringement. That is the correct maximum number, but that's not necessarily what they're going to get. In order to state a claim for copyright infringement, a plaintiff must plead specific original works that are subject of copyright claim, the plaintiff owns copyrights, the copyrights were registered, and that there was copyright infringement. Okay, the complaint does not satisfy, etc. So first they're going to say that they don't satisfy the basic elements of a copyright infringement claim, in that there has to be a registration, a timely registration. And if there's not a timely registration, then all they have is actual damages to fall back on. So that's a valid thing. And we're going to find out whether Exclusively has a valid registration or not. Then they're saying that Exclusively is not the proper plaintiff. But I want to get to this part. The complaint shows that Ms. Hadid's use of the photograph was permissible. So remember, we're talking about, this is a represented party, a lawyer, in fact, a law firm of more than one lawyer has put their name on this and said that this is a valid legal defense. So let's see what their valid legal defense is. Even aside from those obvious deficiencies, the ownership issues above, the complaint establishes that Ms. Hadid's reposting of the photograph to her personal Instagram page was fair use and consistent with an implied license. Those are two separate things. Both are affirmative defenses. Both are saying, yes, we committed copyright copying or other infringement, but our infringement is protected by law as a permissible use and therefore not infringement. So this is two separate things, fair use and implied license. Fair use. Fair use doctrine espouses an equitable rule of reason, allowing others to use the copyrighted material in a reasonable manner without the author's consent. It requires an open-ended and context-sensitive inquiry and considers 4 statutory factors from Section 107. Has been applied in a wide variety of contexts to limit an author's rights to the original work. They cite the Authors Guild v. Google case, Swatch v. Bloomberg, and then they go on to say that all 4 fair use factors favor Ms. Hadid. The first factor assesses the purpose and character of the use. Let's see what she says. Ms. Hadid merely reposted the photograph to her Instagram page and made no effort to commercially exploit it. Her reposting thus reflected a personal purpose, different than the photographer's purpose in taking the photograph. This is not the standard for transformation. Absolutely not the standard for transformation. But they're citing a case, I'm assuming they're misciting a case here, that says that the first factor favors a defendant where the defendant's purposes in using the image in a collage were sharply different from plaintiff's goals. Yeah, this misrepresents Stern v. Lavender, where the collage, it was a situation, if you've ever seen one of those collages that has like thousands of images making up the collage, yeah, the image was one of the thousands of images. So was Ms. Hadid's purpose to put the photograph into a collage of thousands of images that, when viewed from afar, make up a larger or different image? No, she reposted with a crop. So they're saying here then that her reposting was allowed because her purpose was personal and the photographer's purpose was commercial. That's not how fair use law works. Even if Ms. Hadid's alleged use was not transformative, its non-commercial nature weighs strongly in her favor. Do we really think that the #1 model in the world, that her Instagram is non-commercial? #1 model in the world, highest paid model in the world. And she's trying to say that it's transformative because it's not commercial. That's not how that works either. The second factor looks at the nature of the copyrighted work. The published photograph depicts Ms. Hadid smiling, standing in front of a nondescript building. It is not a studio composition, but a quick shot in a public setting. Yes, but the photographer's interest in a copyright has been very clearly established, that they still have to have a camera pointed at the right thing, focus. They have to choose exposure settings. They have to choose a lens. They have to choose the medium, as in what size sensor in the camera and all that. So these are all creative inputs, and photographs are most definitely copyright protected. There is no allegation that the photographer attempted to convey ideas, emotions, or in any way influence the subject's pose, expression, or clothing. Wow. Okay, so they're trying to remake the copyright standard, saying that it's only, your photographs are only copyrightable if you did something. In this case, they're saying attempting to convey ideas or emotions or influence the subject's pose, expression, or clothing. So a nature photographer would have to influence their subject in order for their nature photograph to be protected. I don't think so. There is a protectable copyright interest in taking photos of what happens. And she's a thing that's happening. She's the most popular model, at least by pay or whatever. And there's no doubt that the photographer's, his or her, photographs are copyrightable. In that the second factor strongly favors Ms. Hadid here because Ms. Hadid posed for the camera and thus herself contributed to the elements that copyright law seeks to protect. She's not the one that fixed anything in a tangible medium of expression, but she's trying to say that somehow, and her lawyers, by the way, are trying to say that her posing somehow causes her to become part of the creative input and is therefore, she has like a work for hire agreement or an implied license. This, if I was the opposing attorney, I'd be making a Rule 11 sanctions argument about this. This is ridiculous. Case law does not support this in any way. But that's what she said, where creative features come not from the photographer, but rather from the subject. Holding the subject liable for infringement does nothing to foster what the Copyright Act values. And they're citing to Hathi Trust, saying that the ultimate test of fair use is what the copyright's goals would be better served by allowing the use than preventing it. That's not what that stands for. I don't even have to read the case, and I know that's not what that stands for. The third factor considers the amount and substantiality of the portion used in relation to the original work, and they're going to say that because she cropped it, she used 50% of the original, which completely ignores that you could crop out stuff that isn't important to the photograph. So if she crops it out so it's now zoomed in, what did she zoom in on? Did she zoom in on the wall? No, she zoomed in on her face. She zoomed in on her body, the heart of the photograph. Her lawyers know this and yet still signed this document. So she's cropped herself, and that somehow gets past the third fair use factor. The fourth factor is the effect on the market. So this is going to be whether someone seeing her Instagram post no longer has to go see the photographer's picture. And they're saying that the complaint does not allege that Ms. Hadid's use deprived of them of any significant revenue. That's not the fourth fair use factor. It's market usurpation, not actual damages. These lawyers, sometimes people get paid more than me, and I get a little bitter about it because they do a crappy job, and they should be getting more money for doing a better job, not more money for being incompetent and committing Rule 11 violations, in my humble opinion. Finally, the other relevant considerations that courts should consider also weigh in Ms. Hadid's favor. She's popular, and the paparazzi potential to profit is tied to the fame of their subjects. the paparazzi take advantage of her by surveilling her. It is one thing to allow them to sell a photograph for profit, but it's another to demand damages based on an Instagram post by the very person whose image the photographer sought to exploit in the first place. The phrasing, to demand damages based on an Instagram post by the very person whose image, almost sounds like she's saying she thinks she has a possessory interest in images of herself, in images that contain herself. That is not how copyright works. That is not how fair use works. Let's see, though, what she says about... Oh, well, before we get to implied license, she says, more pointedly, the photograph here was only possible because she cooperated in the photograph's creation. Although it can be disruptive and unsettling to encounter anonymous men with cameras as she goes out. She knows that there are women too, like women are also paparazzi photographers, and there are some damn fine ones too. Anyway, anonymous men with cameras are unsettling to encounter as she goes about her daily life. In this instance, she indulged the photographer and posed only by permitting subjects to make minimal personal use of the paparazzi photographs in which they appear, will subjects remain willing. Oh, wow. Only by permitting subjects to make minimal use of their... So she's saying that she should be permitted to use the photograph because it encourages her to interact with the photographer instead of encouraging her to not interact with the photographer. This has nothing to do with copyright. Accordingly, to the extent copyright law seeks to promote the creation of photographs like the one at issue here, the goal would be better served by allowing Ms. Hadid's use than preventing it. No. The goal of copyright law is to protect the photographer's use here, not your use of the photographer's photograph. Anyway, she goes on about implied license. Exclusives claims also fail because the complaint shows that Ms. Hadid had an implied license. Under federal law, non-exclusive licenses may be granted orally or may be implied from conduct. Although the law on implied license shows a measure of conflict, courts generally look to the party's conduct. Such objective conduct is present here. As the complaint's exhibits show, Ms. Hadid encountered the photographer as she exited a building. She stopped to permit the photographer to take her picture and, by posing, contributed to the photograph's protectable elements. No, she did not contribute to the protectable elements. In that moment, the photographer elected to take a photograph which was indisputably made more valuable through Ms. Hadid's participation in its creation. In other words, only as a result of the mutual actions of Ms. Hadid and the photographer was a photograph of a smiling Ms. Hadid even possible. In those circumstances, a license can and should be implied, permitting Ms. Hadid to use the photograph, at least in ways that do not interfere with the photographer's ability to profit. And of course, this does interfere with the photographer's ability to profit. People who went to her Instagram page and saw that photograph don't have to go buy a copy of whatever company, of whatever publication the company that sold the photograph published it in, whether it be the National Enquirer or Newsweek or whatever. That photograph is less valuable, and the market has been usurped, and these attorneys don't understand copyright law at all. Or they intentionally misunderstand it, which is offensive to me, and offensive to Federal Rule Civil Procedure 11, and Rule 1 of their duties of competency. Sorry, getting on my high horse a little bit. All right, I'm going to skip the rest, and let's just see if there's anything in the opposition of this motion to dismiss. So this is exclusively's opposition. And they agree that she is indeed a famous American supermodel. However, she's also a brand. She's estimated to be the world's highest paid supermodel with a net worth of $20 million. She receives significant income from modeling, as well as by serving as a pitch woman for various advertising companies with global reach, including Prada, Sunglass Hut, Reebok, Tommy Hilfiger, Missoni, Stuart Weitzman, Moschino, Tom Ford, and Fendi. She maintains and supports her brand by keeping herself in the news by chronicling her exploits on social media, including Instagram. As of the date of this filing, she has more than 47 million Instagram followers. She regularly posts photographs of herself to her Instagram account and that are not her intellectual property, and for which she has not properly received permission nor license from the copyright holder. Prior to the current lawsuit, Hadid was the subject of a nearly identical suit that claims she infringed on a photographer's copyright work by posting uploading the image to her Instagram and Twitter accounts. Since she settled the previous case, she has continued to exploit the intellectual property of others, improperly claiming she is entitled to exploit the images because she is a subject, while simultaneously decrying the actions of photographers who capture the image she appropriates for her financial gain. And I'm going to stop there because when we eventually get the ruling on this, we're going to go over everything that Exclusively is about to go over in their thing about how basically copyright doesn't work like that. And I think it'll be much more interesting to read the judge's summary than to go over it here and make a longer video, especially when we're already over time on our live stream. So she's definitely a brand. She definitely doesn't have the right to use other photographers' photographs. She can set up a camera herself, or she can hire a crew herself and take her own photographs if she wants to have something similar to what that photographer made. And then it can't be substantially similar because you can also infringe copyright by recreating another photographer's work, even in a photograph. So be careful about that. Anyway, do we have any questions? Let us know in your thoughts in the comments below, and I'll try to respond to them, because I find this to be a fascinating case where not only has Ms. Hadid, it's understandable that Ms. Hadid feels in a way about it. She's got a brand, she doesn't like the paparazzi profiting from the brand, and she feels that this should play out differently. However, the law does, in fact, and in law, have it play out differently. So she's wrong. But I'm not too upset with her for being wrong. Let's be clear, I am not really upset with Gigi Hadid for being wrong. It's these people here at the bottom. Let me put, I'm not gonna put up their phone numbers and stuff, but it's the attorneys that submitted this. Oh yeah, this is the wrong attorneys anyway, so I'm glad I didn't do it. It's the Quinn, Craig, Nissimian, the attorneys for defendant, New York, on Fifth Avenue. A Fifth Avenue law firm doesn't understand copyright law. No, I humbly submit my opinion and speculation that a Fifth Avenue law firm wants to take a profitable and wealthy client's money. That's what I think is happening here. And if I was involved in the case, I would be crying ethics and possibly submitting some kind of Rule 11 sanctions motion. Maybe the plaintiff is still going to consider that if they double down on this. Yeah, so the trick is actually making a lot of photos together into a collage. Go read the Snorre case and you'll find out what the requirements are in that circuit. I forget if it's a Supreme Court case or not, but you'll find out what the requirements are for making a collage. Yes, if you take other people's photographs and make a collage out of them so much so that your individual photographs are almost unrecognizable from the normal viewing distance of the now larger image, yeah, that's a different thing than an Instagram page. That is our show, everyone. Thank you very much for joining me today. We will produce these videos into the stories that will drop on YouTube this week. We thank you very much for your support, because YouTube has a habit of regularly demonetizing our videos, and it has cut our production profits by a lot, by over 2/3. And we now have Tactical on staff helping us on the law side and occasionally helping us on the YouTube side. And Brandon is on Lawful Masses staff. He gets paid for editing the videos. And so we have financial obligations every month. Our legal news service that allows us to access these stories and documents and things easily is $1,200 a year, et cetera, et cetera, et cetera. So we have some expenses on our end, and YouTube keeps messing with the demonetization. For example, the Joey Johnson story, we put out 2 videos. One is just an extended version of the other. The extended version is fully monetized and confirmed. The shorter version is fully demonetized and confirmed. That makes no sense. They're both the exact same video. One is just longer. So that makes no sense. Anyway, so support us on sponsus.org/law or patreon.com/ljfrench. Thank you very much to our supporters in the month of July. We have a $500 supporter this month, Joshua Davis from TandaPay. We're going to be doing a video about his social insurance program. It's really interesting. It's based on blockchain technology, and it's really, really interesting, and we're going to try and figure out if there's a way we can get this idea to stick in people's heads. I think that's what he's fighting now, is trying to get the idea, because there's too many complicated things to it. Social insurance, what's that? Blockchain, you're going to add that into it, and now people just put it out of their minds. So Joshua Davis from TandaPay, we thank you for your support, and we're looking forward to doing your video on your social insurance program. Thank you also to the $50 plus supporters: John Steele, Gavin Barnard, Kyle Mudrak, Eevi, Michael Pearce, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, and Snorre Wisotzky. And thank you to the $5 plus supporters who are also scrolling on the LED panel above me, and all of you will be in the description of the videos below. I am Leonard French. I am your favorite copyright attorney, and I will leave some room here for super slow-mo dog video and any other dog video that we've got here, because we shot, I don't know, an hour's worth of dog pool party video between regular slow-mo, like 60 frames per second, and then slowing that down. And then we did some 1080p, I think it was 480 frames per second or 240 frames per second, super slow-mo, and then slowed that down to its 60 frames per second equivalent, and made a whole video for you, and we're going to drop parts of that in the various videos. I think I even dropped some of that today in the video I dropped this morning.
Yes,
so,
it is.
Anyway, love you all. See you next time. I'm Leonard French, your favorite copyright attorney. This has been Kaylee here in the studio with us, and Brandon has been in the virtual studio. Thank you all for coming. Love you all, and I'll see you later.